Good morning. Welcome to Sherman and Howard's webinar presentation on DOL doubles overtime pay requirements. My name is Vance Knapp, and I am a member of the firm's Labor and Employment Practice Group. I'm pleased to be here today to introduce our presenters, Andy Boland and Erica Herrera, who will be discussing the impact of the U.S. Department of Labor's new regulations for the overtime exemptions under the FLSA on your company. In addition, Andy and Erica will be providing recommendations on how to prepare your business for the regulations when they become effective this December. Logistics. Before we get started, let me briefly address a few logistical issues. In the unlikely event you are disconnected, please reconnect by going back to the same link you initially used to sign into the webinar. If you have technical difficulties, please call 800-843-9166 for immediate assistance. Again, that number is 800-843-9166. We encourage you to ask questions during this presentation. You're able to submit questions during the presentation using the chat box on the left of your screen. If it is not visible, the chat box can be opened by clicking on the chat box in the bar at the top of the screen. We have reserved some time for question and answers at the end of the program, and we'll provide your questions to the presenters during that time. We are recording today's program. We will circulate a follow-up email to all participants later this week with a copy of the recording and the PowerPoint slides, which you can share or continue to use as a resource, so keep an eye out for that in your inboxes. With the housekeeping out of the way, let's get started. Our presenters today are Andy Boland and Erica Herrera. Andy helps employers minimize risk from problems with their workforce, and when disputes arise, he helps management present their side of the story. Having been with Sherman and Howard for over 25 years, he advises and defends private sector employers and their management in disputes involving employment discrimination, wrongful discharge, and wage and hour law. Erica Herrera is an associate in the Labor and Employment Department. Erica joined Sherman and Howard last year after clerking for the Honorable Martin F. Egelhoff of the Denver District Court for 2 years. She now assists employers in a variety of labor and employment law issues. One final note, Andy and Erica, along with a team of our other lawyers, were successful in a recent case against the EEOC, so I believe that you're in excellent hands this morning. Andy and Erica, take it away.
Thanks, Vance. Well, good morning, everybody, and thank you for joining us today. There's over 300 of you on the line, and that's a pretty remarkable level of interest in regulations that were really only announced 2 weeks ago. May 23rd is when the big news came, the news we'd been waiting for over a year. And if you're interested, you can actually look at the official notice in the Federal Register from May 23rd. It starts on page 32,391 of this year's Federal Register and continues for 161 pages of single-spaced, triple-column, tiny font text. But if you're not interested in going through that exercise, you're in the right place because Eric and I will tell you all about it in the next few minutes. We have a special welcome because there are some people on the line who are clients of ours, and we're very happy that you decided to sign up. Hello, you know who you are. And also we have some people who joined us last year when we put on the webinar, because the proposed rule came out last summer, and we put a webinar on at that time. And if you participated in that webinar, you'll be pleased to know that this version has some of the same information from last year, but of course it's new and improved because now we have the actual information, not just the proposed rule, and we have more concrete information on what you can do to prepare. So we're very pleased to have you here with us today. I'll also say that for people like me and Vance and Erica who practice wage and hour on a regular basis, these new regulations really are the biggest development in wage and hour law for many, many years. And we think it's so exciting that we talk about it every day. It's like getting fresh air and exercise. You know, you have to do that every day. Well, for wage and hour nerds, it's the same thing. So we're very pleased to be able to share this with you today. And after we're done, our goal is that you will be ready to move on to the next phase, which is how to analyze what you're going to do for your business. With over 300 people, as you might expect, there is a wide variety of expertise and familiarity among this group. And so we're going to start by just recognizing that there's a variety of levels of sophistication in the audience today. So there could be some people who are saying, I'm not sure what the FLSA stands for. And of course, the FLSA is the Fair Labor Standards Act, which is the source for these new regulations. And then more familiarity, people who know what the FLSA stands for, but maybe they don't quite know the details. They're starting out in the field. And then maybe there are some of you who already know the current overtime exemptions, and you stay up to speed. And then finally, there's people who have been following the developments from over a year ago, well, almost 2 years ago, when the change started to take place. And then there's a few of you out there, and we know who you are, that actually could present this seminar yourselves. Okay, let's talk about the agenda. We're going to right away give you a summary of what the changes are, so that if that's all you really need, you can get that information right away. And then we're going to talk about the timeline to make sure we understand where we've been and where we're going. And then we're going to back away from these new regulations to talk about the overview of the FLSA and an overview of the white-collar exemptions. And then once we do that, we're going to go right back into the nitty-gritty details about these changes, information about timing, and then practical steps, lots of alternatives for your business. At the end of the program, we're going to take questions, so we look forward to addressing any questions that you have. Okay, the summary of the changes. Here's the big news. They're more than doubling. The government is more than doubling the minimum weekly salary for people who are going to be treated as exempt under the white-collar exemptions. So that's your executive, your administrative, your professional employees, and also this includes, and this is not discussed very often in the the newspaper stories, but the exemption for what's called highly compensated employees and also the computer-related occupation exemptions. And this new minimum, it's doubled to over $900 a week, or about $47.5 a year. Not exactly that, but pretty close to that. Not only that, it's going to automatically update every 3 years. For those of you who've been working in this field for a while, you know the last time the salary level was changed was 2004. So it's been 12 years, and the Department of Labor's approach now has changed. Instead of waiting for some event to look at this, they're going to automatically update it every 3 years. And so your next update is going to be in January 1 of 2020. Of course, these regulations go into effect in December of this year. And so every 3 years they're going to automatically update, and they've promised us 150 days advance notice before that happens. Okay, let's backtrack a little bit. We know that for most of these white-collar exemptions, there's three main elements, three legs of the stool that you have to have in order to be exempt. And one of them is the salary level, how much you have to pay somebody. But there's also that you have to pay people on a salary basis. And then the third component is that for any particular exemption, the employee must perform the duties required for that exemption. So what the Department of Labor is doing is changing the salary amount or the salary level, but not the salary basis or the duties components. So to the extent this is overwhelming, it could have been worse. And in fact, they were considering more changes than what they actually did. Okay, here's our timeline. So 2004, I think I mentioned this, that's when the overtime exemptions were last revised. That's when the current salary level of $455 a week was established. And so it's been a long time. And then 10 years later, in March of 2014, President Obama said it's time to make a change. And most people in this industry expected that a change would be announced and a proposed rule would come out fairly quickly. But instead, there was a significant delay. It wasn't until last summer that the proposed rule was published. And of course, that's right over the holiday weekend last summer. Ask me what I did over that holiday weekend. Anyway, so then it wasn't until May of this year that the final rule was published, so 2 weeks ago, as I mentioned. And they've given us, a few months' notice. It's not going to be effective until December 1. So we had lots of headlines in the last 2 weeks about this. and there's lots of information being distributed. But take a deep breath, relax. There's time to figure out what you should do for your business. And then, as I mentioned, it's not until 2020 that we have the next adjustment. Erica?
Good morning, everyone. Thank you all for joining us in this webinar. I'm very excited to be here to talk with you about these new regulations. We're going to start with an overview of the FLSA, and this is for those of you who fall into that category that Andy mentioned of those who know what the FLSA stands for but don't know the details. For the rest of you, if this is a refresher, then we invite you to just sit back, relax, and let the information become even further ingrained in your memory. The FLSA was enacted in 1938 and is one of our nation's oldest federal employment laws. If you're listening and you're wondering if your business is even subject to the FLSA, it's a safe bet that it is because of the minimal requirements for coverage. You only have to meet a low minimum dollar threshold of $500,000 per year in revenue or have a worker who is engaged in interstate commerce. I've been in practice for a relatively short period of time, but I know that Andy, our wage and hour expert, has been in practice for over 25 years, and in that time has only had one client not subject to the FLSA. So if you're listening, then you're probably covered. The FLSA imposes three main substantive requirements: overtime, minimum wage, and equal pay. The overtime requirement is a weekly standard. Employees are entitled to 1.5 times their regular rate of pay for hours worked over 40 in a week. As we all know, some employees are exempt from overtime, and today we're going to talk in detail about the so-called white-collar exemptions. The second of the three main requirements under the FLSA is minimum wage. The current federal minimum wage is $7.25 an hour, and that number has not increased since 2009. Note, though, that this is the federal minimum wage, and your state or local minimum wage might be higher. The minimum wage in Colorado, for example, is currently $8.31 under the state's minimum wage order. Just like the overtime requirement, the minimum wage requirement has exemptions for a variety of industries and positions. The third main substantive requirement in the FLSA is equal pay. Many people don't know this, but the Equal Pay Act is part of the FLSA, and it prohibits pay discrimination on the basis of sex. As a side note, Title VII also prohibits pay discrimination on the basis of sex, and those of you familiar with this statute might know that the Lilly-Ledbetter Act of 2009 significantly expanded the statute of limitations for bringing those claims. Overtime, minimum wage, and equal pay are the main requirements, but the FLSA imposes other requirements as well. And these last two bullet points on the slide, you'll see it also imposes child labor laws and record-keeping requirements. The FLSA not only creates substantive rights, but it also contains enforcement provisions. Looking at the first bullet point on the slide, under the remedies provisions, an employer may be liable for unpaid wages, but also double damages referred to as liquidated damages. The FLSA also provides for recovery of attorney's fees, which attorney's fees in a dispute can easily dwarf the amount of wages that are owed. The statute of limitations, looking at the second bullet point, or the time period within which an employee can bring a wage claim under the FLSA, is normally 2 years from when a claim arises, but if the failure to pay wages is willful, and most claims do allege willful conduct, limitation period is increased to 3 years. Another enforcement weapon under the FLSA is collective actions. A collective action is like a class action, except when a court certifies a collective action, participants have to affirmatively opt into the class. This is unlike a class action where participants may instead opt out of the class. The FLSA also provides protection from retaliation. Like most employment statutes, if an employee complains about a wage violation, they're protected from termination or any other adverse action stemming from their complaint. Unlike Title VII, there's no administrative prerequisite to filing a lawsuit under the FLSA. Employees can go straight to court and they can file a claim long after their employment ends, or they can file a claim while they're a current employee. The FLSA also allows for individual liability. So compliance and what we're talking about is important to protect both your business and those individuals directly involved in FLSA violations, for example, business owners or payroll administrators. That's the basic overview of the FLSA, but it's important to remember that state and local laws may also apply. Most states have their own version of the FLSA imposing state minimum wage and overtime requirements and exemptions. A trend in recent years is for local jurisdictions, cities and municipalities to enact their own minimum wage requirements that are much higher than the federal requirements. This is important because employers have to comply with the law that provides the greatest protection. Even if you're in compliance with the FLSA, you could still run afoul of state or local laws, and to say that you at least complied with the FLSA is no defense. Turning now to the FLSA's overtime exemptions. There are many exemptions that apply to both minimum wage and overtime, and there are many exemptions that apply just to overtime. More specifically, there are 18 exemption categories that apply to both minimum wage and overtime, and 30 exemption categories that apply to just overtime. We're focusing today on the white-collar exemptions, which apply to both minimum wage and overtime. Under the statute, white-collar exemptions cover those employed in bona fide executive, administrative, professional, or outside sales occupations. The statute gives the Department of Labor the authority to interpret the statute when those terms, to interpret the statute and when those terms apply. It's pursuant to that authority that the Department of Labor has issued the new salary level regulations. There are some additional overtime exemptions worth noting. One is the exemption for certain computer-related occupations, which Congress added to the statute in the 1990s. For those listeners familiar with the statute's organization or disorganization, the executive administrative professional exemptions are located at Section 213A1, or as they like to sometimes shorten it, just 13A1. But the computer-related occupations are located in a separate section, Section 13A17. Another is the exemption for highly compensated employees, which the Department of Labor added to the regulations when it last made changes in 2004. Highly compensated employees are those who are paid much more than the minimum salary level, but may not closely fit the white-collar duties requirements. So for those employees, the salary level test is higher, but the duties test is relaxed. Under the current version of the regulations, the minimum salary level for highly compensated employees is $100,000 per year, and as Andy will explain later, that will increase to $134,000 under the new rule.
Well, yeah, actually a little bit over $134,000, but isn't that a significant increase? Like to be one of those people, highly compensated employees, with this new regulation. Okay, let's talk about the exemptions. And I alluded to this earlier, the three legs of the stool, or the three requirements for the white-collar exemption. And the first one is the duties test, and we're going to be going through that just to review them. But I want to assure you at the outset, the good news is they did not make any changes to the duties test. Another component is the salary basis test, which is very important, and often mistakes are made on this area, and that creates risk for lawsuits. And again, the good news is no changes to the salary basis test. And then the third one, the amount of the salary, that's a significant change.
So here's our overview of the duties tests that apply to each of the white-collar exemptions we've mentioned so far. And as Andy just said, there's no change to these tests under the new rule. This is just review. The first slide here relates to the executive exemption. For the exemption to apply, the executive's primary duty under the test must be management. The term primary duty, as you might suspect, refers to the main or most important duty that the employee performs. And for the executive exemption to apply, the employee must be in charge of a part of the business and must direct the work of at least two full-time employees or their equivalent. Equivalent could be 1 full-time employee and 2 part-time employees, for example. And they must have the authority to hire or fire employees, or at least their recommendations as to hiring, firing, promotion, or other changes of status must be given particular weight. Turning to the administrative exemption, for the administrative exemption to apply, the employee's primary duty must be the performance of non-manual work or office work directly related to the management or general business operations, and the duties must include the exercise of discretion and independent judgment over matters of significance. Disputes under this exemption often involve whether an employee has the required degree of discretion. That depends on a variety of factors articulated in the regulations. Next is the professional exemption, and there are 2 subtypes under this exemption. The first is the learned professional, an engineer or someone with a specialized academic degree. Notably, certain computer professionals may qualify for exempt status under this exemption, as well as the separate exemption I mentioned earlier. For the learned professional exemption to apply, the employee's primary duty must be the performance of work requiring advanced knowledge, or work that's predominantly intellectual in character. Like the administrative exemption, this exemption, both its subparts, also requires consistent exercise of discretion and judgment. Advanced knowledge must be in the field of science or learning, and the advanced knowledge must be customarily acquired by prolonged course of specialized intellectual instruction, although there could be special circumstances where advanced knowledge is gained through a combination of work experience and intellectual instruction. The second subtype is the creative professional. Artists, musicians, actors, for example, their primary duty must be the performance of work requiring invention, imagination, originality, or talent in one of those recognized fields of artistic or creative endeavor. Next is the exemption that I've mentioned for certain computer-related occupations, which Congress added to the statute in the 90s. This exemption covers computer system analysts, computer programmers, software engineers, or other similarly skilled workers. This exemption doesn't apply to basic data entry employees. It applies to highly skilled computer-related occupations. Notably, when this exemption applies, the employee can be paid on either an hourly or a salary basis and still be exempt from the overtime requirements. The employee's primary duty under this exemption must consist of the application of systems analysis techniques and procedures, including consulting with users to determine hardware, software, or system functional specifications, or going to the next slide, you'll see that only the second subpart of the subpart under the second bullet point has changed. Design, development, documentation, analysis, creation, testing, or modification of computer systems. Again, not basic data entry or other simple computer work or even maintenance or repair, but systems analysis or design. Finally, with respect to the computer-related occupations exemption, still looking at that second bullet point, the exemption may also apply to employees performing a combination of analysis or design duties that I've mentioned, requiring the same level of skills.
Thanks, Erica. The three legs of the stool: the duties, the salary level, the salary basis. Now we've talked about the duties not changing. Salary basis test not changing. This is important and good news. But because people sometimes make mistakes with this, we thought it would be useful to go over it again. Exempt workers have to be paid their full salary for any week in which they perform work, regardless of how much work they do. And there's only very limited circumstances when you can make a deduction from the exempt worker's salary without jeopardizing their exempt status. And you have to have a policy in place with a complaint mechanism in case there's an improper deduction. And of course, what we're going to suggest is that your complaint mechanism is much more robust than that, so that it can encompass any kind of wage hour issue or problem or concern, not just a complaint procedure about improper deductions, although the regulations are very specific that for this salary basis you need to have a complaint mechanism with at least that in place. What type of disputes have we seen in the past about overtime exemptions? Typically, people say, you're treating me as exempt, but my duties actually don't meet the requirements of the particular exemption in dispute. And it's very clear under the law that if you want to treat somebody as exempt, it's the employer's burden to show that. In other words, it's an affirmative defense to a claim for a violation of the FLSA that someone should be treated as exempt, and that means the employer has the burden of proof, which means you need to be sure that the duties that people perform actually meet the requirements of the exemption in dispute. So, for example, the administrative exemption, Erica reminded us that they have to perform matters involving discretion and independent judgment. Well, we see lots of cases where people say, all I do is apply rote formulas or policies. I don't have any discretion. I don't use independent judgment. Therefore, I really should not be treated as exempt. So make sure that the people you're treating as exempt actually do fit the duties requirements for the particular exemption in dispute. And then another one that creates problems is improper deductions. For example, someone takes off half a day, takes Friday afternoon off because they want to do something for personal reasons. Well, it's pretty clear under the regulations that absences of less than a full day can't result in a deduction. So be careful before you make a deduction. On the other hand, salary level disputes have been very uncommon for the white-collar exemptions, and that's because the current amount, $455 a week, is just so low. Most people don't have a problem establishing that problem. And of course, if you do have a problem with how you're treating your exempt employees, it could be sort of the tip of the iceberg situation, because one error may mean that a whole segment of your workforce is affected by it. And when there's a problem, if there's liability, you have no record of hours worked, and so the damages can be quite significant. So what's the big change? Doubling. It used to be about $24,000 a year on an annual basis, and now it's going to be closer to $47,500, so more than doubling. And also a change in how we're going to set the salary level. Previously, it was just a hard dollar amount, the $455. But now we're going to have an automatic update every 3 years, so that's very significant. How did they come up with this number? Well, they pegged it to the Bureau of Labor Statistics, 40th percentile for salaried workers in the country. And what the BLS does is they have different regions of the country. And so what the DOL has done is say, we're going to use the 40th percentile in the lowest wage region. And so now that's the South, and that's how they came up with the $913 a week. It's interesting to note on the slide, it says the proposed rule was $921 a week. And when the proposed rule came out last year and they were discussing this approach, they took that 921 from data back in 2013. So they were actually suggesting then that the final rule might be more than that. But instead it's slightly less. I know that's not a lot of encouragement for the people who are writing the checks, but still it's a little bit less than what they suggested it would be. And of course it's going to change every 3 years. The highly compensated employees, Erica mentioned this, so let's talk a little bit more about that. They perform exempt duties, but they may not strictly meet all the requirements for any of the particular exemptions. And rather than having disputes about how many angels are on the head of a pin with respect to their duties, the Department of Labor said, if you just pay them $100,000 in total compensation and they're close enough, we'll consider them exempt. And that has worked pretty well for the last 12 years or so. But now in the new regulation, they're saying we're going to peg this amount to the 90th percentile of the salaried workers, and that's not going to be in the lowest wage region either. That's going to be nationally. And so that's now going to be over $134,000. And of course, if you pay people that you want to meet this exemption, if you pay them on the salary basis, the weekly amount must still be at least the $913 level. So you can pay them $913 a week, but then at the end of the year, you have to make sure that they get the difference so that they're over that amount. That would be quite a nice bonus at the end of the year. Okay, another change, computer-related occupations. Right now, they can be paid on an hourly basis or a salaried basis if they meet the exemption under the white-collar exemption. And that hourly rate of $27.63 is something that was put in the statute, not in a regulation. And of course, the Department of Labor doesn't have the authority to change the statute itself. So for those people, you can still just pay them $27.63 an hour if you want. And if they satisfy those duties tests, they're still going to be exempt from overtime. Or if you want to pay them on a salary basis and they meet the duties tests for one of the white-collar exemptions, then you can pay them on a salary basis of at least $913. Okay, who is not affected? Let's talk about that. So there are some white-collar exemptions that the weekly salary level does not apply to. You think to yourself, well, that hasn't been reported very much in the newspapers, but it's always been the case that there are certain occupations that aren't subject to the salary level test. That's the normal salary level test. So, for example, professionals, some of the learned professionals like teachers, doctors, lawyers, not subject to the salary level test, which means you can pay a doctor, a lawyer, or a teacher whatever salary you want, and as long as they perform the duties required for that exemption, they're going to be exempt from overtime. And of course, also outside salespeople, the salary level test does not apply to them. Here's another change. The salary level test in the past was just a straight weekly amount. And in the proposed rule published about a year ago, one of the things the Department of Labor solicited comments about was whether they should move away from a strict salary and allow employers to include other elements of compensation. And they got a lot of comments about that. In fact, the Federal Register suggests that they received over hundreds of thousands of comments in response to the proposed rule. And so they now have this new ability that you can include up to 10% of the salary of that $913 minimum can be based on things that are other than the salary. So things like commission payments, incentive payments, non-discretionary bonuses, those things can be up to 10% of the minimum weekly salary amount. And you don't have to pay them that every week. You can do that on a quarterly basis. So this is a little complicated, and there is a regulation, the new regulation on it, and we don't have much guidance on how it's going to be enforced. But if you're interested in pursuing that, we encourage you to take a look at that regulation because this is the first time something like that has been available. Erica?
Is the sky falling? How will this affect your business, and what changes in compensation will you have to make? We'll start with what stays the same. Chances are you have a number of employees who are not currently exempt from the FLSA's overtime requirements. No changes there. Overtime requirements continue to apply to those employees. Also, no effect on those exemptions that Andy just mentioned, not subject to the salary requirement. Outside sales employees, teachers, attorneys, doctors, and also those that meet the computer employee exemption, which is the odd exemption that allows for compensation on an hourly or salary basis. And there has been no change to the hourly salary level of $27.63 per hour. So who will be affected? The Wage and Hour Division estimates that over 4 million workers will no longer qualify as exempt from overtime. The hardest hit industries will likely include health services, wholesale, retail, and hospitality. The hardest hit jobs are likely store managers and middle management, and the hardest hit region will be the south and rural areas because of typically lower salary levels in those regions.
Well, what are we going to do about this? If we don't make any kind of changes in our business or our compensation for employees as we look at total labor costs, overtime costs are going to dramatically increase because more people are going to become eligible for overtime as a result of this. So what is the fix? Well, the first thing we need to do is we have to look at who we're treating as exempt now and what their responsibilities are and how many hours they work. And we have to determine whether this creates an opportunity for us to make some changes moving forward. And as part of that, anyone who is sort of in that area between the old minimum and the new minimum, we need to identify their hours worked. Because part of what we're going to decide to do is going to be based on what their actual hours worked. And for many of those people, because they've been exempt, we may not have been tracking their hours worked, and that is going to be a big change. So between now and December, we must put on our to-do list, figure out how many hours these people are actually working. And then, as part of that, we have to look at staffing levels. Because if we have a bunch of people who were not willing to dramatically increase their salary, and they're working lots of overtime hours on a regular basis, maybe we want to have more people working fewer hours. And then finally, of course, and this is something that the Department of Labor does not say very loudly, but it's entirely permissible. We can change people from exempt to hourly. We can change wage rates to account for the additional overtime that may be owed. So let's talk now about a variety of potential options. And our first option is the easiest one, and the one that the Department of Labor would like all of us to do, and I think all of the employees impacted would also prefer that we choose this. And in these examples that I'm going to go through now, they'll all be about, I use my own name so that I'm not picking on anybody. So Andy, the assistant manager, I'm making $40,000 a year now, so I'm exempt. But come December 1, no longer exempt. What are we going to do with me? Well, you can raise my salary to $50,000 a year. Thank you very much. Your labor costs have increased, but at least you know what they are. There's no need to track my hours because I'm still going to be exempt. So it's all good, right? Here's the wrinkle, what I call the ripple effect. What about the people who were being paid $45? Are the people who were being paid $47? Are the people who are being paid $50 now? If you raise me to $50, what are you going to do with those people's compensation? It raises an impact for people, even those who are more than the current, or more than the proposed or the new regulation. Okay, here's another example. Let's move me to hourly based on a 40-hour week. So move me to from $40,000 a year. Let's make me a $20 an hour employee. So if I assume 2,000 hours in a year, 50 weeks of work at 40 hours a week, that's $20 an hour. And then if I work overtime, it's time and a half, costs you $30 an hour. Your labor cost is going to depend on how many overtime hours I work every week. And that may vary. It depends on the job and the worker, right? But the key here is now, Andy, you must track my hours. Before you didn't have to track my hours. Now you have to track all my hours worked daily, especially whether I have overtime hours over the course of a week. Third option. This time, and the math is going to get more complicated as we go on. You're going to make me an hourly person, and you're going to actually know the actual hours I work, and you're going to convert me based on my actual hours so the net cost remains the same. So here's, in my example, I'm working 50 hours a week. If you do the reverse math, if you now switch me to an hourly rate of $14.54, my first 40 hours costs $582, and then my next 10 hours, it's $218 for the overtime. The $582 and the $218 is $800, and bam, I'm right back at $40,000 a year. So that could be a no net increase in compensation approach. Of course, I'm kind of shocked because I thought I was a kind of a big deal, salaried guy at 40 grand a year, assistant manager, and now you're saying I'm an hourly worker that makes 14 bucks an hour. That could kind of be a big shock to my system, and if there's a lot of Andys out there in your workforce, you got to think about morale and communication strategies. And you're going to be tracking my hours every week. Here's a fourth option. You're going to make me salaried non-exempt. Before I was salaried exempt. Now I'm salaried non-exempt. You still have to pay me overtime if I work overtime. So in this example, I work 50 hours a week. You're going to pay me a salary of $582 a week, and then because I work 10 hours, I'm going to get that overtime of $218. It's the same number. So you're paying overtime for additional hours. You still have to track hours. It's really a good approach if you have a job with consistent overtime. What if Andy works only 30 hours? I still get my salary of $582, right? So it sort of becomes like a minimum guarantee for me, which is helpful. But of course, that minimum is a lot less than what I was used to. And for my personal finances and budgeting, I'm going to be very nervous about whether or not I'm going to be getting those overtime hours I used to have. And of course, if I work 60 hours a week, your labor costs are going to go over that. So this may be right for some positions, may be wrong for others. Okay, here's a more complicated example. This time, we have a fluctuating work week, and the salary that you're going to pay me is for all the hours I work, not just for 40 hours. It's for all the hours I work. And if that's the case, you only have the overtime is 0.5. It's not 1.5 because I've already been paid for hours, in my example, hours 41 through 50. You already paid me for those. You just haven't paid me the overtime, so it's 0.5. Now, you have to track the hours, and there's a special regulation about this. You have to follow special rules. Make sure you know the lay of the land before you go down this path. But if you look at the example, I'm working 50 hours a week. My salary is $727, which I feel a lot better about compared to the last example. But my overtime is half time, $72.70. I'm back to $800 a week or 40 grand a year. What if I only work 35 hours? Well, I still get my salary, $727, because it's for all the hours worked. So there's 5 different options. And of course, what we're focusing on now is sort of the big picture. And this, even with the big picture, this is a lot of information. But there are some wrinkles in these regulations for certain occupations or certain industries. And so depending on your particular business, there may be something else you might be able to do. But for the vast majority of people, these are some good options. Erica?
We'd like to raise just a couple of logistical points about timing. Under the final rule, the minimum salary level will automatically adjust every 3 years, as we've said. The new salary level goes into effect on December 1st, 2016, and the first automatic increase will occur on January 1st, 2020. In planning for the new rule and increases, if you already provide annual or other periodic salary increases, one suggestion is that you might want to revisit the timing of these normal increases to coincide with DOL adjustments. So if you currently provide salary adjustments at the end of your fiscal year or increases corresponding with work anniversary dates, for example, you may want to change those to occur on January 1. This is simply for ease, so you only have one annual increase to plan for and implement. Additionally, as changes take place every 3 years, This might be obvious, but you'll want to monitor those employees who are close to the salary threshold so that an exempt employee does not suddenly become non-exempt without proper planning. We mentioned that the DOL will publish the updated rates in the Federal Register at least 150 days before their effective date. So you'll know well in advance what the new salary levels are, and the updated levels will also be posted on the Wage and Hour Division website. As I said, the first increase will occur January 1st, 2020, so with that 150 days, your first advance warning is set to occur on August 1st, 2019. With regard to record keeping, again, for those employees close to the minimum salary level, you might want to require timekeeping even though you're treating them as exempt, just as a safety net. This way, if a dispute arises as to the proper classification of exempt or non-exempt, you have a record of all hours worked so you know what overtime hours you're dealing with. Also, if you have an employee who is close to the threshold and they're consistently working 40 hours a week, you'll find this out through record keeping, and you can make an informed decision as to whether you want to continue to treat that employee as exempt or not. And I'll note that requiring salaried employees to track their time doesn't have to be difficult or complicated. One option is just to require the employee to submit a record of their hours worked at the end of each pay period. The Department of Labor doesn't require any special form or method. It's whatever method is effective and efficient for your business and your workforce. We've had questions in the past about whether requiring employees to track their time will somehow convert them from exempt to non-exempt. And the answer to that is no. Exempt status depends on, as we've discussed, those three main elements: the salary basis, the salary level, and duties, not on a requirement to track hours. Another consideration regarding employees close to the salary threshold involves other areas of compensation, such as benefits. If you decide to adjust an employee's rate of pay in response to the new regulations, this is just a reminder to consider their total compensation, the big picture, including benefits the employee might receive in making your adjustments.
One of the things I mentioned when we were talking about these examples and with Andy, the assistant manager, is morale issues. And let's come back to that. You know, for the first time, there's going to be millions of workers who have never tracked time, and they now have to. Now, that doesn't mean they have to punch a time clock, but you are required as the employer to have an accurate record of their hours worked every day and on a weekly basis. And the idea that people are salaried but non-exempt, that's an idea that really we haven't talked about in a long time, but it's something that we can come back to. So we have to deal with morale issues because people are no longer going to be salaried exempt, and they've thought of themselves in a particular way because of that. And we're going to have to train them on how to track their time. And if you're not used to tracking your time, it may be more likely that you don't accurately report all your time worked. And that's going to be a significant challenge for us moving forward, because think about the workers who may be exempt now that may perform work outside the physical premises of your offices. So someone who responds to emails or phone calls outside normal work hours and off premises. How are we going to track the time associated with that? That's a difficult question, and we need to come up with some answers in the next few months, because it's very clear under this law that it's our obligation to have accurate records of time worked. There's a few other risks. In the next few months, as companies decide what they're going to do, they're going to be announcing changes. And even if your company is okay, the company next door is going to be making changes. And your employees are going to be talking to their neighbors, and their neighbors are going to be discussing the changes. So we have to think about that, because all of these workers are going to be talking about what they make and sharing that information and sharing how it's going to be changed. And that's a dynamic that we really haven't seen on a nationwide basis before. And of course, other federal laws, such as the National Labor Relations Act, which covers all workers, and state and local laws, expressly give employees the right to talk about terms and conditions of employment, including wages. So you can't impose some sort of confidentiality blanket on these kind of discussions. They're going to take place, and they're allowed to do so. And so when that happens and people compare notes, we need to make sure that if there's a problem, like with pay equity, people doing the same job being paid differently, and there's no legitimate non-discriminatory reason for that, that we're able to respond to that. And that's why part of your analysis right now needs to uncover those potential problem areas and address them in the few months that we have, so that December 1, when these new regulations are effective, everything is in order, our ducks are in a row. And of course, we have to have a lot of training for these people who are going to be likely to work off the clock. And when I say off the clock, I don't mean the time clock. What I mean is a problem accurately reporting their hours worked. So that's why we have to rethink total compensation, because what we focused on in this presentation, and we are in the home stretch, but what we focused on is the salary versus hourly. But of course, total compensation is much broader than that. Your labor costs are much broader than that. And so think about how the benefits that you provide come into your total labor costs, and whether or not you need to reconsider that mix of the different types of compensation and benefits as you move forward. Okay, what additional resources do you have? Hopefully this has really been helpful. We've put a lot of time and effort into making it helpful, but we can also point you in other directions for more help. So the Department of Labor Wage Hour Division website has got a wealth of information on it, lots of fact sheets, booklets, information. You can find the actual regulations there. If you want to read the 161 pages in the Federal Register, that's in single space, triple column, tiny font, you can find it there. So it's all there for you. Is there anything else you really need to know? Yes. Yes. All the newspapers are reporting is the headlines about these new changes, but there's been a few other really significant developments in wage hour law of the last year that you need to know. As soon as the proposed rule came out over the holiday weekend last year, a week later, the Wage Hour Division issued this administrative interpretation about the suffer or permit standard, which talks about the problem that they see with employers choosing to classify workers as independent contractors rather than employees, and by classifying them as independent contractors, trying to avoid the obligation to pay overtime. Well, you see on the slide here, my E does not equal IC, and that's sort of a nod to Albert Einstein, obviously, and E equals MC squared. But employees are not independent contractors. Don't try to take an easy way out by saying, I'm just going to reclassify these employees as independent contractors, because it's very difficult to treat someone who's working for you as an independent contractor rather than an employee. Something else you need to know. Earlier this year, the administrator also said, we're going to look closely at this concept of joint employment. And joint employment can be either horizontal or vertical. So horizontal is associated companies that share workers, and if my example is a cook that works at two different restaurants, 30 hours at one restaurant, then he goes to the other restaurant and works 30 hours in the same week. They don't pay overtime because they say it's two different companies and he's only working 30 hours a week at each company. Well, what the administrator is saying is that's a joint employment situation. That's 60 hours, so you owe them 20 hours of overtime. A vertical integration example is when you use a staffing agency or PEO for workers to provide services. Well, they have to comply with the FLSA, and if they don't, you may be liable. So very important information. So let's get ready. And of course, when we talk about that, we have to also consider that there's state wage hour requirements as well. So depending on what state you operate in, and many businesses operate in multiple states, you need to make sure you're complying with it. Whatever law provides the most protection. Here's some things that you can do as part of your next steps, now that you know the lay of the land. Think about who's exempt or not exempt and how people have been classified. Think about special categories of workers like interns, and do an overall assessment of whether you're properly compensating people. Also look at time worked and off-the-clock potential issues. So do you look at data about either time cards or other kind of recording mechanisms? And if you have practices that can be attacked, like for example, there used to be some industries where they would automatically deduct a half hour for a lunch break for employees, even though some of those employees claim they didn't get that half hour. This is something, a time now to address things like that. When you have people report their work hours, make sure they verify that those hours are accurate. And then if there's a problem, make sure you have a complaint mechanism that is extremely robust so that any kind of wage hour issue can be reported and resolved quickly before it becomes too significant.
So now you know the Fair Labor Standards Act, or at least have a better understanding of the upcoming changes to the minimum salary level for the white-collar overtime exemptions. So spread the word, start preparing, identify potential options. Also, plan communications with your workforce, work with payroll, and work with legal counsel to enhance confidentiality of the analysis of your pay structures. Thank you all very much. We do have a few questions here for the Q&A portion of the presentation. And the first question that we have is, if an employer has a PTO vacation policy and it states if a salaried employee misses less than a full day, the employer can have them use their PTO vacation for time missed. Is that correct? What's the minimum an employer is safe to require them to use?
That's an excellent question, and that really goes to the salary basis test. You're paying someone on a salary basis, and I said improper deductions jeopardize that. And so this is an example about what about an absence of less than a full day? Well, in this example, you're not reducing their salary because you're actually just reducing their PTO balance, which is a benefit different than their salary. That's perfectly acceptable. Where sometimes people get into trouble is, let's say you have a new employee, maybe only around for a couple months, they don't have a balance in their PTO bank, and then they have a half a day absence. What do you do then? Well, don't jeopardize that exempt status. If they get the time off, just let them carry a negative balance. That's the easy answer. You're not reducing the actual salary.
The next question, the highly compensated provision. Does that mean that someone less than $134,000 may be eligible for overtime if they meet other criteria? And does it mean no matter what, if they make over $134,000, they cannot be eligible for overtime under any circumstances? Andy?
Yeah, let's talk more about the highly compensated employee. These are people whose total annual compensation has to be over that minimum, right? And then they also have to be paid on a weekly salary that's at least the weekly minimum, and then they have to perform exempt duties. So the only difference between these people and the executive, administrative, or professional people is that we're not going to apply those duties tests quite as strictly to them. So close enough is good enough for these people.
Question. If a position has a salary range of, say, $45,000 to $55,000, instead of just making the $45,000 employees non-exempt, should we consider making the position itself non-exempt regardless of where the employee may fall in that range?
That's an excellent question. And depending on your business, that may be the entirely correct answer. It will depend on what the actual hours are of the people in those job duties And if you want to be able to, if you feel comfortable that you're going to be able to track their hours worked, you can make them all non-exempt and then figure out what the payroll cost should be based on their actual hours worked, doing the math as I illustrated in my examples.
Question: what is the best way to track hours for potentially impacted folks who are exempt today? Paren, we don't have those folks do timesheets, etc. today.
There is no best way. There is no required way. The requirement is that you have accurate records. So you can choose whichever manner is best for your business. So for the next few months, if you're not sure what's best, you can try a number of different approaches and see which one turns up accurate, easy to administrate records, because you have a lot of flexibility. You don't need to make people punch a time clock literally. That's not required by this law. What is required is what has always been required for non-exempt hourly workers, and that is keep an accurate record of their hours worked. That is about all of our time. So thank you very much. And if there are a couple of questions we didn't have time to answer, and we'd be happy to respond to those by email. We appreciate everybody's time and interest in this topic. And if you have questions or desires for another presentation, please let us know, and we'll do our best to make it happen. Thank you, and have a great day.
I echo Andy's comments, and thank you very much for listening.